Hello guys. I need you guys to listen to what the prospects of this case against INEC and Tinubu um, is as explained by the former Minister of Justice and the Federation Attorney General, former Attorney General and Minister of Justice of Nigeria. Um, he has the way he has explained things is very very reasonable, and I think everything is in the right course. It's just left for the Labour Party and PDP to present their case to prove that INEC has actually violated the guideline and the constitution and the laws that they made, as a precedence of running the election. So once they're able to establish that, and the man also explained properly that based on the understanding of the electoral process and the electoral law as interpreted back in 2008 when President Buhari challenged the election result as well back then. He actually affirmed that the Supreme Court understand and interpreted the law that the president needs to get 25% minimum of 24 from 24 states of the 36 states plus 25% on the Federal Capital Territory, FCT. So getting that 25% of the Federal Capital Territory is mandatory. It's a must. So if you don't have that, you should not and cannot be the president of Nigeria, as interpreted back in 2008. So if that interpretation is still in effect, then Tinubu cannot be sworn in. But if the Supreme Court has done another interpretation of that clause, then there's an issue. Do you understand? Which needs to further interpretation. But as it is right now, there've not been any presidential election tribunal that has taken place since 2008. So that means the judgment of 2008 should still be in effect. The interpretation of the law should still be in effect since then. So right now, they're going to go from that. So just watch the video and just understand that we're in the right course. All right, man. Much love and peace. Just updating you on hearing from the highest, the most learned authority in law in Nigeria, election law, tribunal law in Nigeria. All right, just watch it and take note. Much love and peace.
Former Minister of Justice and Attorney General of the Federation, Michael Aondoka, has now joined us to shed more light on this matter, as well as other matters arising from the polity at this time. Thank you so much, sir, for joining us on Newsday. Welcome. Now, there were Now, there were fears of a constitutional crisis as the 2023 presidential election results began trickling in, with some analysts saying the winner must win 25% of valid votes in at least 24 states of the Federation and the Federal Capital Territory. In fact, some thought, winning 25% of the votes in the Federal Capital Territory would be the deciding factor in who wins the election. Well, the president-elect clearly did not get 25% of the votes in the FCT. So is this a good enough ground to question the validity of the results?
Well, thank you very much. It's a very difficult situation, but I think the matter has been interpreted before, around 2008, in a matter involving the current president, Buhari, when he filed an action. The issue of whether that and in between, that is, must have 25% in two states and the Federal Capital Territory. I think the pronouncement then was that the "and" is conjunctively. That was the interpretation then. But you know, it's about 14 years ago. It's enough time, maybe the Supreme Court may have another look on it. But as of now, that is the interpretation the Supreme Court gave in 2008. I don't want to go into details because the matter is now sub judice. About some states have already filed an action to challenge the legality of the election. So I am confining myself to what was the interpretation of the Supreme Court in Buhari's case in 2008.
Okay, just
the interpretation simply was that.
Sorry to interrupt you. I just wanted to get some clarification, which I'm sure is what you're saying right now. So please proceed.
Yeah, that's what I'm saying. I'm saying I cannot go deep into the matter because already actions have been filed at the Supreme Court. And I'm just giving you an instance where there was an interpretation by the Supreme Court of that provision or a similar provision. The interpretation was that "and" federal capital should be construed conjunctively. In other words, it means you must get the 2 days, the 25% in 2 days, and also you must get 25% in the Federal Capital Territory. If you go by the interpretation of the Supreme Court in 2008. But I say, look, the Supreme Court have a right to depart from its previous decisions if the justice of the case demands so. So I don't know if they are confronted with similar interpretation, they will follow their own previous decision, or they might depart from their previous decisions. That's why I gave you that answer. But I will not go further because the matter is before the Supreme Court, and 6 states have already gone to court to have the election voided. Now, of course, the 2 political parties, PDP and Labour Party, also have commenced legal actions at the Presidential Tribunal, which is the Court of Appeal. So it will not be proper for me to go deep into the matter. And that's why I didn't even cite the citation. But it's a case I'm very sure was decided in 2008. It involved the current president, and a clear interpretation was given on that.
All right, fair enough. Fair enough. Thank you for expounding on that and explaining it a little further. It seems that it's a war of semantics in more than one case, not only with the "and" or Federal Capital Territory, but the words now are transfer versus transmit. And I'm speaking about IREV and BVAS, transmission versus transfer. A few days back, Senate President Ahmed Lawan, well, he said at plenary that the National Assembly only made provisions for the transfer of results from polling units to the INEC server. Now, this is contrary to the narrative that INEC has been selling on advertisements all over multiple television screens and even in newspapers, telling the country about real-time transmission of results that can be seen by all in order to create transparency. This particular sticking point, is this another credible angle that some or more of the parties might use to argue their case?
Certainly is going to be an issue, because the position of the Supreme Court then and now are guidelines flowing from INEC have constitutional flavor. The guidelines flowing from INEC in the conduct of elections have constitutional flavor. Even in party politics, the Supreme Court has retaliated that party guidelines also ought to be obeyed. How much with, not to talk of INEC guidelines, which flows directly from the Constitution, because they get the powers to enact, to issue out guidelines based on the power donated to INEC to conduct the election by the Constitution. If they have consistently issued guidelines alluding to the fact that the result will be transmitted live from the polling unit, not just here, all over, even at Chatham House, it will be a serious issue. They will have good reasons to tell the Supreme Court or to the Presidential Tribunal why they deviated from that guidelines. And they must also justify deviating from that guideline did not affect substantially the result of the election. That is going to be an issue. Not just an ordinary issue, but a very serious issue. Because the issue of others feeling that they have been misled, others feeling that there's improper motive behind the sudden change. Because if you are issued guidelines to the effect that results will be transmitted directly from the polling unit, and it becomes impossible, you have to also issue guidelines countering that, varying the reasons why. But it does appear in this case that you are changing the goalpost in the middle of the game. That would be a little difficult to explain. But I've said these matters are before the court, and the court's Nigerian judiciary is courageous, very courageous enough to see whether that sudden change without notice created issues of transparency on the election. That will be a very great question to ask. The big question is, why did you keep drumming on that issue? They may have a reason, but until that reason is adduced, if at the trial and it becomes public, if not, the presumption will be obvious that something not right happened. Not right in favor of INEC or not right in in favor of the parties. Maybe INEC have a reason why they suddenly did that in the middle of the election. But I've said not transmitting the result as alluded by them consistently will be a serious issue. Thank you.
That 6 states have petitioned the Supreme Court to nullify the outcome of the presidential election. But I'd like to know if it should be the states, making such petitions. If I might borrow your legal term, do they have the locus standi to do that?
If you follow the recent judgment of the Supreme Court by Naira redesignation by CBN, with approval of the problem. In one of the clauses, the judges of the Supreme Court, in their wisdom, said there's a norm principle. CBN has a norm principle, which is the president. And the conduct of election vested in INEC is also the duty of the federal government to ensure elections are transparently conducted. If you follow that judgment, which was just delivered today, it will be difficult to say the state don't have jurisdiction, because they also have stakeholders. And they also were aware that for the protection of their citizens, they were aware that INEC gave assurance that results will be transmitted from the polling units. Just like in the matter relating to the Naira issue, there's sufficient interest alluded. In Naira issue, the state governors, in their wisdom, and correctly went to court to protect their people. They felt the policy created hardship and was unjust on them. And Supreme Court said they have a right. How much the issue of leadership, who governs this country, must be a matter of all the federation state. It must be a matter of concerns to everybody. And everybody, I think that is an area that we will wait to see whether they have jurisdiction. The rights, I have not read the claim sufficiently to me to make comments, and then even if I read sufficiently, I will not make comments because the matter is before the court. I am only commenting on the fact that the recent judgment seemed to create a window for states to do that type of thing.
Okay, all right, thank you for that. Concerning the judiciary, it seems like this is their high season, so to speak, with the conduct of the elections the week before, and obviously not this weekend, but the upper weekend. Do you foresee a lot of court back and forths, people running to the court in order to get their to get justice in one sake or another? And do you see the judiciary as being overburdened? Does this worry you that there might be quite a lot of back and forths? And is it possible for, in this particular case, with the presidency and the 6 states going to the Supreme Court, in a similar vein, could the parties link up together to join a class action suit? I don't know, I'm not a lawyer. I'm trying to find the right terms in order for you to understand what I'm saying. In order for them to join together to sue the government, is that a possibility for them to do?
Well, let me answer you. The judiciary has been unfairly overburdened because every single election, pre-election matter went to Supreme Court. And when the judges in their wisdom follow the law, some try to infer morality. I'll give you one example, the case of the Senate president. There has been laid down procedure and precedent by the Supreme Court that issues of forgery or falsification, which are criminal in nature, requires reasonable doubt, even in civil proceedings. Therefore, where a matter is commenced in such a way that the standard of proof is beyond reasonable doubt because the criminal elements there requires the other party to answer it, and it is commenced in such a way that such proof cannot be. Morality will be otherwise, but Supreme Court must have followed the law to say, look, you did not commence this matter in a proper matter. It ought to have come by writ of summons instead of originating summons. But coming to the current situations, individual people who are affected, the Constitution gives them the right to challenge an action where they are an aspirant. But at the same time, I am saying you, don't forget that before governors took the Naira issue to the Supreme Court, individuals who felt aggrieved went to the Federal High Court, one in Kano, one in Akwa Ibom, one in Oka, to challenge the action of the governor. Some did and lost. But the governors still went to the Supreme Court in a collective form to protect the rights of their citizens residing within them who do faith have suffering. So I believe that is the premise which some of the state governors have gone to court. Ordinary, it would have been those who are aspirant, but the action is not premised on the Electoral Act, but it's premised on the constitutional provision that INEC, this is the powers, these are the regulations you made flowing from the constitutional provision giving you power to conduct the election. This is what you said, and you have done the opposite. You have violated the Constitution. That is the scenario that is playing up here. For a person challenging an action in court relating to an election, he must be an aspirant. But here is another angle where INEC exercises its powers and rolled out guidelines which have constitutional power. That's what the Supreme Court said. and INEC now deliberately or by omission did not follow the guidelines, then the states could have felt that their people are surcharged and have a right to approach the Supreme Court to give the interpretation. I think that is what is playing out here. But at the same time, I told you, I cannot go into the details of this because actions have already gone to court and will wait. But I have the highest confidence in the Nigerian judiciary, especially the Supreme Court, because they do not decide based on sentiment. It's not always what is law that morality will be. It's what the law sometimes do not come out the way you, a clergyman or an ordinary person, will look at it. But if Supreme Court decide otherwise in a certain manner, it will be overrun itself on several cases that will distort the doctrine of precedent. So that is that.
Well,
so I still maintain that it does appear the governors have seen the window in the last case just decided today. In fact, they also have a right to collectively, 6 of them, challenge the conduct of this election, hinging on the constitutional powers INEC have abused, allegedly abused.
Guys, if we don't get justice in this case to prove that this election was fraudulent and many millions, thousands of people were disenfranchised from exercising their right, their civil right to vote and choose who they want to lead them, this is what we might get.
I am addressing Nigerians today that we must do everything to retrieve the stolen mandate by Bola Ahmed Tinubu, because we cannot have a man who is suffering from advanced dementia as the president of the Federal Republic of Nigeria. If we allow this to stay, will Nigerians imagine Bola Ahmed Tinubu addressing the United Nations and possibly as president addressing the United Nations, he will introduce himself and say, I am Bola Ahmed Tinubu, the president of Burkina Faso. Do you know the international damnation, the international condemnation, the international ridicule that will, bring on Nigeria and Nigerians? So we must do everything to make sure that we restore and retrieve the people's mandate. As I'm speaking with you, area boys in Lagos are already relocating to Abuja. There's excitement in the highland. All the bad boys, the area boys, are already planning to move to Abuja, where their grandmaster is relocating to. And I want to say, very soon you will start seeing snatching of bags, you will see snatching of phones, you will see breaking into people's cars, because area boys will invade Abuja. Marijuana will become very popular. Drugs like cocaine, heroin will be sold like pure water on the streets. And people like MC Oluomo will relocate to Abuja. And NURTW will now also take over the metropolis of Abuja. We should not allow that to happen in a sane society, in a civil society. So I call on Nigerians to say the battle to retrieve the mandate of the people is a battle of no retreat, no surrender. We must recover. We must recover. We must recover the people's mandate. Never should we allow a drug baron certified by the court of law to be the president of the Federal Republic of Nigeria. Pablo can never be the president of the Federal Republic of Nigeria. Thank you. I remain Dino Elai.